Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Haziq Syahmi bin Muhammad Nur Rosdan from Group 6, and now I want to present about the introduction. Okay, so the land transfer process in Malaysia can be categorized into various issues, including in matters of fraud and misrepresentation, which are among the topics or issues that want to be highlighted. These issues can have significant legal and financial implications for the parties or victims involved either intentionally or unintentionally. This matter is very important to be understood by all levels of society, especially in relation to the nature of these issues and their potential impact on land transaction in Malaysia. The purpose of this published review is to study the case of fraud and misrepresentation in land transaction in Malaysia carefully and from authentic reference source to find the cause and provide guidance to the community so that case like this no longer occur in our country. This is because land transactions are one of the main contributors to the development of business profits for the Malaysian economy sector. There is also no doubt that one of the biggest causes of fraud and misrepresentation in land transaction in Malaysia is due to corrupt practice among the superiors who manage important documents for transaction, as well as the negligence of certain parties, resulting in buyers and investors receiving losses that big in this land transaction. This review will delve further into this case. That's all from me. Thank you.
The first case, pendaftar hak milik negeri Selangor versus Caesars Development Sdn Bhd and another appeal. In this case, pendaftar hak milik negeri Selangor filed an appeal against Caesars Development Sdn Bhd and others in the land dispute. The plaintiff, Caesars Development Sdn Bhd, claimed that the landowner was true and sold to the registered owner of the land, and the name change was fraudulent. The plaintiffs also claimed that the transfer of the land and issue of the computerized individual document of title (IDT) to the first and second defendant were invalid, as they were not bona fide purchaser for valuable consideration could not be protected by proviso to section 340 subsection 3 of the National Land Code (NLC). The High Court judge determined that the land registration in favour of the third defendant was invalid due to forged document and fraudulent transfer. The subsequent transfer of the owner to the first and second defendant were also nullified. The judge found the seventh defendant negligent and in a breach of statutory duty, but there was no proof that the plaintiff will suffer actual losses from the fraudulent transaction. The Court of Appeal looked into Section 8 of the 14th Schedule of NLC, National Land Code, which state that compensation change is not to be valid unless the previous original title was submitted to the registrar. The seven defendants continue to change and register the title without a previous surrender of the original title, and no investigation were made by the officers at the seven defendants officers as to the veracity of the title being described.
My name is Muhammad Daniel Akid bin Zadif, matric number AP220073. I'll explain the case law Teo Han Sang and others versus Teo Ki Sang and another 1999. This case revolved around a land dispute arising from a transfer made 20 years earlier by father of two of his seven sons. The remaining brothers contended that the land was held in trust for all siblings, while the defendants asserted that they had legitimately purchased it for 3,000 ringgit Malaysia. The crucial legal context is provided by the National Land Code 1965, specifically Section 340, subsection 1, which establishes the indivisibility of the title. This means that the defendant's ownership of the land is considered indisputable unless evidence of fraud, misrepresentation, or unlawful acts is presented. The court affirmed this principle, emphasizing the legal strength of the defendant's title under the National Land Code. Section 340, subsection 2, outline exception to indivisibility, allowing challenges under specific circumstances. The case underscored the significance of proving fraud or other specified wrongdoing to overcome the general rule of indivisibility, providing legal clarity within the framework of land transaction governed by the National Land Code 1965.
Third case, To Puan Di Hayati Abdul Rahim versus Lau Bantin and Ano. In this appeal, the plaintiff claim was not based on any contract for the sale and purchase of land. Her claim was based on the breach of the undertaking by the defendant under the SSA to cause the company to transfer the land to the plaintiff. The land had been registered in the company name and later it was transferred to the first defendant. When the plaintiff issued the notice of demand in 2014, she knew that the land had been registered in the name of one Tengku Muhammad Kami land Tunku Ramli. Next, in the High Court, the defendant applied under 18 of the Rule of the Court 2012 ROC for the OS to be struck out on the several grounds of irregulative. Next, Case 4. Sagung Tasi and Os versus Kerajaan Negeri Selangor and Os 2002 High Court. In this case, the plaintiff sued in a representative capacity in respect of themselves and on behalf of each and every members of their respective families. The second and sixth plaintiff died and were properly substituted by their respective daughter. The suit was filed as the result of a dispute that arose out of the eviction of the plaintiff and their respective families from 38.477 hectares of lands that situated at Kampung Bukit Tampoi, Dengkil, Selangor. The land was in the shape of a strip running through a Gazette Aboriginal Reserve under the Aboriginal People Act 1954 and also land customarily occupied by the orang asli and therefore classified as a aboriginal area or an aboriginal inhabit place under the act. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Najmi Mustaqim bin Nazri. My metric number is AP220079 and today I will be present the case number 5, which is Tang Ying Hong versus Tang Xiang San and Orcs. First of all, let me tell you about the case. The case is between Tang Ying Hong versus Tang Xiang San and Orcs 2010 involved a registered owner of land that was owned to a bank without the applicant knowledge. The first respondent carried out the charge while working under a fictitious power of attorney. Let's get to know better about the case. So, the case, the appellant Tang Ying Hong was the registered owner of a piece of land in Kuantan. The first respondent, purporting to act under a power of attorney, had executed two charges in favor of third respondent, United Malayan Banking Corp, to secure two loans amounting to RM300,000 Malaysia. For the second respondent, Chini Timber Industry Sdn Bhd, appellant claimed that the PA was forged as he did not sign the PA. He became aware of the forgery when he received a notice of demand dated 9 March 1985 from the third respondent. He then filed a claim in the High Court seeking declaration that the land charge were void in order to remove the memorial of charge against the land from the register, and the issued document of title and an order directing the third respondent to deliver up to him the issued document of title of his land. The High Court judge found that the appellant had never charged the land to the third respondent nor guaranteed the power of attorney to the first respondent, and therefore first respondent had no authority to charge the land to the third respondent. Thus, the registration of appellant in the issue document of title to, was found to be obtained by fraud and forgery. Despite, despite admitting that the appellant titles was registered through fraud or forgery, the High Court ruled in favor of the appellant. The National Land Code (NLC) Section 340 interpretation and the property of the Adorna Properties case decision were at the center of the appellant appeal. Under the direction of Chief Justice Malaysia Zaki Azmi and Arifin Zakaria of Malaya, the court determined that with the exclusion provided by Section 340, Subsection 2 and Subsection 3, registration grants instantaneous indefeasible title under Section 340, Subsection 1 of the National Land Code.
Assalamualaikum warahmatullahi wabarakatuh. I will explain about case 6, Adona Properties Sendirian Berhad vs Bunsom Bunyanit and Lion Sun Yu Eng. According to the result in Adona Properties Sendirian Berhad versus Bunsom Bunyanit 2001, 1 MLJ 241, registration of a land grants instant, indefeasible title or interest under Section 340, subsection 1 of the National Land Code. It's crucial to remember, nevertheless, that the Federal Court reversed this decision in Tan Nin Hong versus Tan Sian San and Aus 2010 to MLJ1 after it was later challenged by academics. The, the court explained that Section 340, Subsection 3, proviso only applied to that subsection and not to any previous subsection, including Section 340, Subsection 2, Paragraph B, which deal with titles obtained through forgery. The court dismissed the claim in the Adona property case that the little was not defeasible because the registration was obtained through forgery. Okay, that's all. Okay, so in conclusion, in Malaysia, transferring land is a complicated procedure with associated legal duties. Like any institution, though, it is not impervious to problems like fraud and deception. In the context of land transfer, fraud is defined as intentional deception or misrepresentation by one party in order to obtain an unfair advantage or monetary gain. To sum up, concerns about fraud and misrepresentation in land transfer in Malaysia underscore the necessity for people to exercise caution, awareness, and knowledge. People can shield themselves from potential financial losses and legal challenges related to fraudulent or misleading land transfer by taking the appropriate safeguards and consulting with professionals. That's all. Thank you.